Hi, my name is Yuan and I'll be talking about privacy harms online and how we need to conceptualize them, or how we can consider conceptualizing them, and particularly seeing these privacy harms as examples of sociotechnical vulnerabilities in Canada's legal system. The first thing I'd like to say is a huge thank you to Serene-risc and the people behind the annual workshop. I'm so grateful for being able to speak as part of this event, and particularly to speak on this topic of privacy as it relates to more potentially vulnerable populations or people who are in vulnerable circumstances. And I'm really grateful to be part of the privacy and gender panel in particular. And I'm grateful to everyone for listening and tuning in. So about me. I currently hold the position of Policy Lead in Technology, Cybersecurity and Technology at Ryerson University. I'm also a research fellow at the Center for Media, Technology and Democracy at the Max Bell School of Public Policy at McGill University. And I'm also a research affiliate at Data and Society Research Institute in New York. And in 2017, I obtained my BCL and LLB at McGill University. So what am I going to talk about today? What can you expect? Well, there's a few things. We're going to talk first about revenge porn and this notion of revenge porn, and how this is a phenomenon, and how this is a way into this topic. I want to talk as well about the problem. So what is the problem that I'm addressing, and what am I seeking to solve? I'll also look at the current law as it stands with respect to what some call revenge porn in Canada, the US, and Australia. I'm going to talk as well about the implications of the problem. So what does it mean that this problem exists? I'll also look at 4 ways forward. And these 4 ways involve incorporating these 4 things all in one, potentially in the Canadian legal system. And then I'm as well address what this looks like. So how can we implement these things going forward in the Canadian system on a practical level? So what are we talking about? Well, we're talking about this thing called revenge porn. So this idea that you can create sexual material, or you can obtain it and you can disseminate it. And the idea with the term revenge is that there's an implication that a person would be sharing this or doing something with it online so as to harm another person or to get back at them. In some countries, this phenomenon of people sharing images without other people's consent that depicts that person who's not given consent is understood in the law as the non-consensual distribution of intimate images. And that is indeed how Canadian and the American and Australian legal systems deal with this phenomenon. But what is the problem? Well, I have questions. When we talk about this idea of non-consensual distribution of intimate images, what is really being protected? What are the assumptions there? I also want to look at who needs to be protected and who should enforce these rights. And just to be a little more concrete as well, I mean, when we talk about something like the non-consensual distribution of intimate images, we're talking about maybe you being in a relationship with someone and saying, you know what, if you're in a long distance, or if you're even not necessarily in the same place, you might want to send a nude. You might want to send an image that conveys that you are intimate with them, or conveys to them something that involves you being nude. And there's also instances when, for example, if you engage in sex work, you might have images of you online that depict you being nude. And if someone were to share these or to use it in any way without your consent, then that is what is often captured. And that is a sort of scenario that this notion of the non-consensual distribution of intimate images tends to involve. But again, the problem is, what are the assumptions in the development of the law, in the development of provisions that talk about intimate images and this idea of non-consensual distribution? So let's talk about what I'm talking about first in these different jurisdictions, and then I'll talk about why that is a problem potentially. So in Canada, we have a new criminal provision, section 162.1 of our criminal law, that makes it a criminal act to distribute without consent the intimate images of another person, and you can face penalty in criminal law in Canada for that. There's also been in Canada and various provinces the enactment of civil legislation, so particularly acts that deal with the non-consensual distribution of intimate images, And therefore what happens is people have recourse under specific laws. And this is the case in places like Manitoba, for example. And these laws are coming in around in various Canadian provinces as we speak. And there are also efforts by people like Hilary Young and Emily Laidlaw, professors in Canada, to actually create a harmonized set of laws that allow people to sue other people because they believe that their images are being distributed without their consent. In the Quebec context, there's also the extension of civil liability as it exists in the Civil Code and as well as under the Charter, because the Canadian Charter, the Quebec Charter, protects people's right to privacy between two independent actors, two individuals, versus just you and the state. In the US context, my research has demonstrated that nearly all, though not all of them, but over 40 states have in fact enacted both criminal and penal provisions against the non-consensual distribution of intimate images. And this means that there's varying levels of punishment that is associated with penal provisions as well as criminal. And then there's also been the enactment of civil legislation at the state level as well. So that is similar to what we see in the provinces in Canada, where in a certain state you can obtain, you have the right to sue someone because they are sharing your intimate images without your consent. In Australia, what we see is combined criminal and civil legislation, which is notable for pretty harsh punishment. So whereas in Canada and the US, there has been the enactment of particularly legislation that has added criminal provisions and resulted in the creation of civil laws that particularly allow someone to have recourse for sharing the non-consensual distribution of their images. In Australia, there's notably one national law that has given people the right to sue and to obtain, to seek criminal, to pursue criminal allegations against someone because of the non-consensual distribution of their intimate images. What's very interesting about the Australian context as well is that their data protection officer, what they call their information officer, actually also gives recourse to individuals against organizations that allows people to request that the organization take down the content. So what that looks like is you say, hello, person who hosts this website, please can you take this content down? And in Australia, the Data Protection Authority will actually do that for you if they believe that your case meets the criteria that they require. But let's talk about the implications. There's three implications to the, in the Canadian, in the American, and to some extent the Australian context, with the creation of law, both criminal and civil, that says that people are not allowed to distribute without consent other people's intimate images. The first thing I observed in my observation in my research of these provisions is the idea from a legal standpoint that the terms images and sharing are in fact not necessarily that inclusive of terms. Now, thankfully in law, you'll notice that if you do any research that, particularly in what I understand in Canadian context, and this is likely true in the US and Australian context, that images actually means videos as well. So it's not that images is itself totally exclusive of a term. However, at this point in time in Canada, you have the right to recourse if someone shares an intimate image of you. What I wonder is what if there is a not necessarily an image of you, but perhaps a doctored image of you. So I wonder what the boundaries of the term image are. And I also wonder about other private kinds of information. So information that you have shared, for example, or sexual information, political information, religious information, and let's call it data. That's exactly what I would like for us to see this as, data. And I also wonder, what if you share your biometric information with someone and they misuse it, or and they share it without your consent? I wonder, what are the limits of the term image? I think that it could be under-inclusive, and the term sharing as well. I think that if we only talk about sharing, then, for example, this could also exclude the idea of deepfakes, because if the person has in fact doctored or edited the image, it seems to me that it's only the sharing that would currently be captured by all of these provisions in these various areas of the law, and not necessarily what has been done to the image, how it's been used without your consent. And just to be clear as well, what I mean by deepfake is the image that is manipulated, that typically includes biometric information such as your face, that is edited in a way that it is made, that it depicts wrong information or inaccurate information, such as your face is put onto someone else's body, or someone else's face is put onto superimposed onto your face, for example. And that's what I mean by deepfakes. The second observation regarding the implications of the problem are that thus far, I think that the issue of revenge porn, or the non-consensual distribution of intimate images, has actually been seen as a sort of sidelined, othered, marginal issue, because in fact I think that women and people who have particular interest in protecting their rights online, and people who are more marginalized situations, such as those who are queer, for example, or not gender conforming, or whose sexuality or sexual orientation is not does not meet the status quo, I think that these are the people who have led the movement to protect their privacy and data protection and consent online. And I think that the even construction of this notion that there is just really a focus on gender and privacy, and if you look at research on revenge porn, on the non-consensual distribution of intimate images, is largely seen as a sexual issue, as a women's rights issue, and it is those things. But I think we're missing something, and I think that not as many people care about this topic as I wish did, because of the way it's been born as a movement. But as you'll see me talk about later as well, I think that everyone deserves data protection rights. Lastly, there's a counterproductivity, I think, in the result of this movement, which is that there has been a reinforcement of the belief that the sexuality of people who are not cis men is shameful and should remain hidden. And what I mean by that is that when you argue that at the heart of the law and what is being protected, and if you look at the non-consensual distribution of intimate images, it's possible to see the assumption that one of the reasons why the images should be hidden is because they are depicting nude images of women. And I think that this is not necessarily the case for every case, that goes before the courts, where an image has been shared without someone's consent. But I think that there is the possibility that the values that are being expressed in the laws that have developed are actually counterproductive, in that they might deprive someone of the right to be able to choose to consensually share their image, because of the ways in which the law has sought to protect something so specific and with values that aren't necessarily explicit about why this really matters. So in the last few minutes, I'll talk about ways forward. And I'll end as well with people you should definitely look into if you're interested in this topic. So the ways forward are me really talking about what I think is the case in the European context. And as well, we can learn, and in Canada, we can also definitely learn about privacy and how to protect it as a data protection issue from the Australian regime. So there's 4 things that I think the Canadian legal system can learn from, particularly because in Canada as a whole, in Quebec, in Ontario, and various other provinces, there are indeed moves right now and pushes to amend our privacy laws. So we are in a time when this is very possible. So I think that there's 4 things that should be incorporated into Canadian law. We should be conscious about the subject and the object of protection. There should be a very specific incentivized action that people should be doing. And there should also be, of course, limits on what people are able to do that results in prohibitions. And of course, it's very important as well for data protection law in Canada to be clear about who it applies to. So this, in sum, to me, revenge porn and the non-consensual distribution of intimate images is really about data protection. It's really about who has the right to control their image, their data. And images are just one kind of personal data. And the reason why this matters is because if we only see the non-consensual distribution of intimate images as a women's issue, or as an issue involving, a marginalized community, then that means we're failing to see the bigger picture and why, in fact, the law needs to develop in less of a reactive way and more of a proactive way. So in the GDPR, what we see is that who deserves data protection rights? It's everyone. In fact, any time you are in the European Union that is covered by the GDPR, you are protected under that law. So you could be even there temporarily and you have rights to that. And it's not just women. It's not just certain populations. It's everyone who has data protection rights. And as I mentioned, I also strongly believe that revenge porn, the non-consensual distribution of intimate images, is fundamentally about data protection. It's about the right to control your data in the way that you wish to have it used and processed and shared. What this means is that I think that to learn from the GDPR, I would hope that the Canadian data protection regime as a whole, in Quebec and in the provinces as well as on the national and federal level, my hope is that there is the encouragement and principle built into the law that when you process data, when you use it and share it, you need to obtain explicit consent for doing that activity. What that means as well is that you would be prohibited, and what would be unlawful is you violating consent. So if you are, you receive someone's image, or if a web host shares your image potentially without you wanting it to be on there, you could say, please take it down. And a data protection officer would be able to process that and issue punishment if that does not happen. Now, that doesn't necessarily mean you go to court, to jail. In fact, there are other ways to obtain justice that don't necessarily involve people being put behind bars. And what we see in GDPR as well is that there's also limits on the processing for special categories of data by people and entities who are covered by the GDPR. So what that looks like is that there are limitations on the processing of biometric data, of data that reveals all these lists of very intimate information about you, such as your religious affiliation, your political beliefs, your health, your sexuality, your sexual orientation, etc. And if organizations such as web hosts or such as search engines, for example, were limited potentially from processing that data in a way that you did not consent, then there would also be able you'd also be able to have the right, for example, to take down that content because it would be violating your consent. And that is exactly what we see in the European context with the idea that you have the right to be forgotten or the right to erasure of your data because you are in control of how your data is used. Lastly, who should the law apply to in Canada and in the provincial context? If we learn from the GDPR, data protection law presumptively presides or covers organizations, particularly private ones. So, for example, organizations that are involved with commercial activity, but then it would also be able to apply to individuals in certain circumstances when a certain threshold is met or a certain scale of sharing or processing is involved. And the idea is that individuals can be captured by data protection law in the GDPR because of the idea that you can all of a sudden bring yourself out of the sphere of what is considered private activity, so amongst you and your friends or your family, or what tends to be consensual or private. And then all of a sudden you can be brought in and captured by GDPR because of the scale, is what I have seen in my research on the GDPR in cases where individuals are covered by the law. And of course, there is the importance for exceptions. So if you're sharing information, for example, of someone that is indeed that needs to be public interest, that is in the public interest to know, then I think it's as well. There are exceptions to who, even though individuals are typically prohibited from being covered by the GDPR, or they could be presumptively covered by it. I think there need to be exceptions that certain public interest activity is carved out, and therefore is still able to be done lawfully under data protection law. So to finish, I'll just talk about what this looks like practically speaking. So in Canada, I believe that we should learn from the data protection model in Australia, where the commissioner there, very much similar to our data protection, well, really what we call the privacy commissioner in Canada and for many of our provinces, I think that we can learn from the Australian model, which responds to and enforces data protection claims. And in the Australian context, they really only deal with organizations and they issue removal notices, saying, for example, to the web host or to a search engine or to a social media entity that they need to take an image down or content down. And of course, I believe that it's possible for this law to apply both to organizations and individuals, so long as there are very carefully crafted exceptions and exceptions to the exceptions as well. And otherwise, I wonder if it makes sense for there to be specialized areas of the court. So for example, in Quebec, for example, and in numerous other provinces and parts of Canada, there are special areas of the court that deal with sexual violence claims. And that's very important because there are special, skills that are involved with dealing with claims that are so sensitive and where there are needs that you need to be trained in order to adequately deal with that case. It seems to me that there could be the creation of courts in Canada, if there isn't a data protection officer that can deal with this, that should be skilled in dealing with something related to this, and it could look like tech-facilitated harms. That is worth another paper and worth more analysis, but that is what I can imagine this practically looking like at the Canadian level. And I'll just cite who's working on these issues. You can definitely take a look at this list later on. I will not read everyone here, but there's many organizations and clinics. There's people on the front lines, and there's people who are providing critical research on these topics, and I absolutely encourage you to look at those people and to read their work and to look at what they're doing, because it's really incredible and very important. So this is all I'll say today. I'm very excited to answer your questions, and please feel free to reach out to me. And I hope it's clear to you that revenge porn, as it's colloquially understood, and the non-consensual distribution of intimate images is indeed about data protection. It's not just about the women in our lives having the right to their images not being shared. It's about you having your right to control your data, regardless of what kind of data it is, and being able to give consent about how it is used and processed and shared. And I hope that we understand that this is not just a women's issue, but it's an issue that everyone should care about. Thank you so much for your time today, and I look forward to speaking about this with you in the future.